seconds to go. Start. Mr. Gupta, while further addressing on merits, submitted that it was not just the allegation of having illicit relationship with a lady judicial officer, but there were other very serious allegations which were unbecoming of a judicial officer, and since the appellant was a probationer, the full court of the High Court found him unsuitable for continuing in service, and accordingly he was dismissed from the service. He further submitted that in the case of the lady judicial officer, whose petition was allowed by the High Court and has since been reinstated to the service, the only allegation against the said lady judicial officer was of carrying on an illicit relationship with the appellant, which the High Court found was without any basis or supporting material. According to him, in the present case, the High Court in the judgment dated 25th October 2018 had clearly held that it was omitting the allegations of illicit relation with the lady judicial officer from consideration, and further relied upon other allegations of misconduct or unsuitability against the appellant, and therefore the appellant cannot claim any advantage or benefit from the judgment in the case of the lady judicial officer. Having considered the submissions advanced at the outset, we make it clear that we are not entering into the merits of the matter, that is, the reconsideration by the High Court in the full court meeting held on 3rd August 2023 and the termination letter issued by the state on 2nd April 2024. These orders could be tested before the High Court by way of a fresh writ petition to be filed by the appellant, and such liberty having been granted by this court in the writ petition under Article 32 of the Constitution of India filed by the appellant, which was withdrawn on 22nd September 2023. For the above reason, the case laws relied upon by Mr. Gupta are not being dealt with, nor are we dealing with the case laws relied upon by Mr. Patwalia. We are only dealing with the MA number 267 of 2024, where the appellant has prayed that he should be reinstated into service as civil judge with all consequential benefits in view of the order dated 20th April 2022 passed by this court allowing the appeal. Once the termination order is set aside and judgment of the High Court dismissing the writ petition challenging the said termination order has also been set aside, the natural consequence is that the employee should be taken back in service and thereafter proceeded with as per the directions. Once the termination order is set aside, then the employee is deemed to be in service. We find no justification in the inaction of the High Court and also the state in not taking back the appellant into service after the order dated 20th April 2022. No decision was taken either by the High Court or by the state of taking back the appellant into service, and no decision was made regarding the back wages from the date the termination order has been passed till the date of reinstatement, which should be the date of the judgment of this court. In any case, the appellant was entitled to salary from the date of judgment dated 20th April 2022 till fresh termination order was passed on 2nd April 2024. The appellant would thus be entitled to full salary for the above period to be calculated with all benefits admissible, treating the appellant to be in continuous service. Story.